Hi, everyone. This is Ruth George, and I'm continuing with my casual conversations. And today I am joined by Tom Hewner. Hey, Tom.
Yes. Hi. How are you? Uh, uh, I guess a little bit about myself. I'm an attorney. I've been an attorney for 30 or 40 years, and I do mostly estate work, guardianships, that type of thing. And I've been doing it for a long time. So that's what I do.
And you are such a fabulous person and a fabulous attorney. So we just are very fortunate to have you in the Buffalo area, and I appreciate all of your valuable contributions.
Thank you. I like being here. So that's a good.
All right, so we thought we would just talk for a few minutes about guardianship proceedings. So why don't you start us off on why we would need a guardianship proceeding?
Well, you need a guardianship proceeding when you have a person who is incapacitated in a way, and they need someone to handle their affairs. Now, their affairs can fall into two areas. Uh, they they can be personal, or they can be property, or personal and property. And so when we move to a guardianship, we move to the guardianship. We have to tell the court what we're looking for. Are we looking for a guardianship of the person, guardianship of the property, or both? Probably both is the more common. So what are they? So guardianship of the property is obviously dealing with a person's assets. Uh, Bank accounts, paying bills, bringing lawsuits, just dealing with their affairs, tax returns, whatever that needs to be done with regard to their assets or their income. Guardianship of the person deals with their personal issues. The big one being obviously medical issues. If you're the guardianship of a person, you can handle their medical, they make medical decisions for them. Guardianship of the person would also allow you to determine where people live. For example, putting people in assisted living or nursing homes or things like that. That's what you need guardianship of the person. The big issue between guardianship of the person, guardianship of the property, and say, when we talk in terms of power of attorneys or healthcare proxies, which is another alternative, is when someone is appointed guardianship of the person or guardianship of the property, the court has to make a decision that the person being subject to this is an incapacitated person. So the rights of that person are actually taken away with to the extent that they have uh, given rights to the guardian, which is different than a power of attorney and a healthcare proxy, where the person does not give up their rights and they can be revoked. A guardianship cannot be revoked. So that's kind of usually the person going to a guardianship probably has never given a power of attorney or a healthcare proxy, because obviously if that was an alternative, you'd probably rather go there than go through a guardianship proceeding.
Yeah.
So it's a very useful, for people who are not able to handle their affairs. It's something that is useful. Anyone, by the way, can bring this. It does not have to be a family member. It can be a friend, or anyone could bring a guardianship if they see that there's a person in need of this kind of intervention. So I kind of I'll go through a little bit the process, because the process is it, I wouldn't say it's difficult, but there is a process. First of all, these things are done in Supreme Court. And so what happens is someone has to bring a petition to the court explaining the circumstances. Usually the petition deals with what is the incapacity of the person. Usually it discusses the income of the person, the assets of the person. It you make a request. These are the powers I need. Guardianship of the person, guardianship of the property. And then identifies who should be noticed, because that's really important. Obviously, the person himself or herself should be noticed, but also if this person has immediate family members, children, spouse, that those type of people, they have to be noticed in this proceeding. Then the person signs that, and then you submit to the court what's known as an order to show cause. At that point, the court, you get assigned a judge, and the judge appoints a person known as the court evaluator, who is usually an attorney, although it doesn't have to be, who is kind of a third party who goes out to this person and just checks it out. Does this person need a guardian? And that could be, that person could go to if given the right authority from the judge, could look at medical records, talk to medical people, talk to physicians. Obviously, if this person's at a nursing home, go there and talk to the people and find out if what the petition says is really true. And the court evaluator will want to make a decision. The court, in certain cases, can also appoint an attorney for the incapacitated person. That is always done under the law if the petition requests a temporary guardian. So if there was something immediate coming up, a temporary guardian can be appointed. A temporary guardian can be appointed, but at the same time, when you appoint a temporary guardian, you have to appoint an attorney for that person. And that's one of the things the court will do, will appoint an attorney for that person. So what happens is all this stuff goes into an effect, and then people show up at court at some point, and the judge will want to know what's going on. The real question is will the petition be opposed? So the person himself, him or herself, could oppose that petition. They can say, I'm not incapacitated in any way. I should not have a guardianship. Or the family members or other people who've been involved, they can oppose that. They can oppose the fact that the person doesn't need a guardian, but they can also oppose the person who's asking to be appointed guardian. And then, of course, the court evaluator will be involved in this situation. At that point, the judge can schedule a hearing, and if a hearing is required, the judge will bring everybody in and have a regular court hearing. We're taking testimony, whatever the issues are, and the court can make a decision regarding the guardianship. Once a person is appointed guardian, then there's annual reporting requirements. That person is given a court examiner. Well, first of all, they have to take a little course. There's a little online course. They have to submit a report 90 days after being appointed. And basically, these are forms and things like that. And then annual reports as to the assets of the person. And these are reviewed by a person called the court examiner, who then reviews it, and if he has any questions, could go to the people involved or go to the court or some such thing. So that's kind of the process. And then these things normally go till the person dies. However, if the person recovers, or the person gets better, or whatever reason they brought it no longer exists, these things can be, guardianships can be reversed. And that's happened occasionally. And so that's kind of the short form of guardianship in the Supreme Court. I'll briefly mention, if you have an incapacitated, a mentally incapacitated person, one can also go to surrogate court. They're called Article 17A guardianships under the Surrogate Court Procedure Act. And where you see that a lot of is when we have children who are under a disability who turn 18. At that point, technically, they can no longer make the parents can no longer make medical decisions for these children. And even though there may be minimal assets or anything like that, that it becomes important for the parents to get medical authority, get medical decision-making authority, because technically medical providers should not be listening to the parents of an 18-year-old child, even though that is a disabled child. Now, a lot of times they will, but eventually they're going to run into a roadblock. So in those cases, a lot of times they'll go through surrogate court and apply to be the 17A guardian of the child. Sometimes you'll have in contested cases there. Sometimes you'll have a contested case and you'll actually have two parents, maybe who have split up, divorced, actually each requesting to be the guardian, and then the court will have to have a hearing and make a decision. So that's something to also think about if people are looking into guardianships.
Yeah, such an excellent review of those guardianship matters, both in surrogates court and Supreme Court, different guardianship proceedings. But what a wonderfully succinct review of guardianship matters. So I really appreciate that.
Good, anytime.
Well, yeah, you'll just have to come back on again because I have a million more subjects for you.
All right. I'm only probably good on a few of those. So.
No. You're so fabulous. I truly appreciate it. And I just thank you for all of your help. You're just one of those people that is just so fabulous. So again,
Okay.
Much appreciation.
All right, good. So I'm glad, hope this is useful.
Yeah, and everybody, as you know, any video I do put out does not establish an attorney-client relationship. This video is for educational purposes only, and I hope you enjoyed it and see you on another video.
All right.